So it's a good time to leverage all of the opportunity that you have to get yourself the best package. And the best way to do that is to make sure you've built this team around you, from a CPA to a wealth advisor to an attorney to an insurance advisor, to understand all the aspects of this job and make sure you're going in with negotiating power and knowledge.
Yeah, Emily, that's a great point. Both about the leverage. It's much easier to negotiate what you need, or at least the most important points of your employment before you take the job. Because once you have the job, you don't have nearly as much leverage to then renegotiate. Now, there will be points in your career, either you're promoted or some other event occurs that will allow you another leverage point at which you can then say, it's time for us to talk about this or that. But this, starting with the promotion or with the job is your best time to get it straight. And the devil really is in the details. Having a salary of X and a bonus of 25% of X isn't everything you need to know, because depending on the details of that bonus as to how it's calculated, when it's paid, what are the circumstances that are required, can make that bonus very real or illusionary. So you have to, the devil is really in the detail.
Absolutely. Thank you, John. Annika, you can move on to the next slide. So now we are going to talk about comparing what you have versus what you will get. Next slide, please. So, I think it probably goes without saying, but it bears repeating, that there's always risks and rewards to considering a move. And that's both a promotional move and a career move. What are some of those factors that you want to consider? I mean, obviously, first of all, in your old job, you've got security, you've got your benefits. Probably you've been at that position long enough that you've built up a lot of paid time off and things of that nature. In some cases, depending on the company you work for, you may have equity incentive compensation grants, like, for example, a restricted share grant or a stock option. And those may or may not be vested, and there could be risk of losing those. You also know what their bonus approach is, how they go about paying out those bonuses. And then, of course, there's the reputation, and hopefully it's a really good one. So, why up and leave all that security and all that comfort for another opportunity? Well, there's plenty of reasons. And not the least of which is you may not have further to advance in your current career. You may be looking for a fresh start because you're not so happy with the reputation you built, or you feel like you've been pigeonholed in some way. So it's worth making the jump. But with all that being said, again, it comes back to make sure you're not jumping out of the frying pan and into the fire, and that as you're making that move, that you've considered all of the factors. And that's really where John and I are going to spend the bulk of our time today, is talking about all those factors and honing in on them.
And that's a great point, Emily. Most people don't leave their job voluntarily because of money. They leave it because they're unhappy, they don't like their boss, or they don't see, they feel unappreciated, or they don't see where their future is, a clear line, to how they will be promoted and when and so forth. And so it really comes down to opportunity. But as you said, you have to look at all the factors of what you're walking away from and understand them before you ever give your notice. If you have options or bonuses or things like that, or anything of that nature, it's very important to understand how they work and what you need to do before you even consider giving notice. If you have non-compete or other restrictive covenants, you need to understand what they provide and what they preclude you from doing before you take on another job or anything like that. So it's very important to understand all of that before you even think about giving notice or leaving your job.
Excellent point, John. And John and I will share later. We have some cautionary tales, some lessons learned from experience as moves were made and not necessarily properly anticipated. I think it's always good to learn from others' mistakes and instead of having to make your own. So we love to share stories with you, and we'll do that here soon. Annika, if you could move on to the next slide. So here's the thing. Changing jobs and getting a new job, it's kind of a little bit like marriage. You're all excited, you really love them, you really want to take that job, and it seems kind of weird, the idea of what I'm going to tell you next, which is this is the perfect time for you to negotiate your way out. Start thinking about your way out on the way in, because it may be the most leverage you have along the route. It's almost kind of like whenever you're getting married and they encourage you to get a prenup and you're like, oh no, I'm not getting a prenup. That puts a bad taste in people's mouths and I'm never getting divorced. Well, we all know that, you know, things happen, things go wrong. And so we should time properly our opportunity to leverage our way out. I have a cautionary tale here I want to share with you. We're going to call him Dave, but Dave was a client of mine actually, and Dave was granted what we would call a retention type grant. And he was so excited, and the company obviously really loved him and they were working really hard to hold on to him. So he just said, yay, thank you. And Dave took said grant. It was a 3-year cliff vesting grant. And lo and behold, about 2.5 years in, Dave had another colleague come along named Joe. And the company, they were kind of jazzed up about Joe, a little more jazzed up about Joe than they were about Dave. And so almost at the 3-year mark, when the grant was supposed to cliff vest, they decided to give Joe Dave's job. And Dave called me and he said, oh my gosh, what can we do? And I did the best I could to connect him with awesome employment attorney. I think actually John Wertschafter, you might have spoken with him, but it might have been before I knew John. And unfortunately, it was a little bit too late. There wasn't much that we could do for Dave. And it was because at the time that Dave was given the grant, we didn't, leverage the opportunity to say, hey, gosh, what if you decide to terminate me, not for cause? Can we make this look a little different in the way it vests? We missed that opportunity to leverage. It was a learning experience. It will never happen again. So, I just wanted to share that with you because although it feels weird, that is a great time to at least make the ask. Can we change this? Can we adjust this? John, do you have anything you want to pipe in with here?
Yeah, I mean, unfortunately, I have too many stories to tell that would highlight, this issue and this opportunity, but I agree with you completely. You're not always going to have the leverage in a new job discussion or negotiation to have severance or to have a significant severance opportunity built into your contract or into your offer. Leverage really comes, it comes over time. In other words, I negotiated my son's first employment agreement and they came back with an offer letter and this and that. And there were probably a dozen things I would have liked to have changed and or revised or provided that they did not have. But he had very little leverage. He was a new employee, fresh out of college. And so we picked the 2 or 3 things that we thought made the most sense. And I always work under the principle that pigs get fed and hogs get slaughtered. And so we limited our request to just these 3 or 4 reasonable things. They gave most of them to us, and the other ones they gave somewhat to us. And it ended up being very beneficial for my son because he got a benefit when he left that none of the other people that were hired at the same time as he got, which was to keep his options and not have to exercise them and to have them continue to stay valuable. So that was just one of the things that we talked about. Whereas I've had, CEOs or very, very successful executives who have a lot of leverage. I mean, they
Mhm.
have multiple alternatives. The company obviously wants them. And there we can go through we might have a list of 25 things that we would like either changed or revised or added. And, they have the attitude of, or if they have the attitude of, well, it's been fun talking with you guys, really appreciate it, but this is important to me. Um, Depending on how much leverage they have, they can potentially get all 25 or pretty close to it. And again, pigs get fed, hogs get slaughtered. It's not a question of beating the employer up over the head with these things. They should be fair, they should be reasonable, but they should also be protective. And everyone goes in with the right intentions of just like a marriage. You go in assuming it's going to last forever, but nowadays it just doesn't generally last forever, either because you are terminated or things changed and it's not the same job or opportunity that it was when they recruited you. So you need to think these things out and feather your nest as well as possible.
Excellent. I think we're ready to move to the next slide, Annika.
Okay, so here we're going to talk a little bit about the offer itself and some of the factors that I think you need to consider and think about. And most of these will make total sense to you, and you probably are already doing, but we wouldn't be doing our job if we didn't just go through with them. So go ahead, Annika, if you move on. So the first thing is, what's in your agreement? And I'm going to say this from both sides. First of all, as I said, you really need to know what your present agreement is, whether it's in writing or not, what restrictive covenants you have, what things that you're walking away from. But aside from that, let's talk about the new opportunity. Most employment is at will, and that simply means that either you can leave whenever you want or they can terminate you whenever they want for any reason or no reason. And then what you're simply negotiating is, okay, if in fact they do terminate me and it is not because I did something outrageous or for cause, or I don't leave simply because I'm tired of it and want to do something else, what do I get? What are my severance rights? What happens to all my benefits? What happens to my equity and other types of programs? And so that you're just negotiating the impact of that termination, but they still can terminate you. It's pretty rare to have a situation where you can only be terminated for cause. It's just not the way that companies work nowadays. They need the flexibility. Things change. And if they decide to move in a different direction, they have to have the ability to terminate people. So it's a pretty rare that anyone is not employed at will. Okay.
And John, I just wanted to pop in here. We had a nice little question here from the group. Thank you, Nancy Valent, for piping in with your question. She asked, can you keep your options even if you leave the company? I know the answer to that question, but I'd love to hear from you, John, and I can add anything.
So typically, if you're granted equity in your old employer, there's two factors. One is, has it vested? So at the time that you leave, has it vested? If it hasn't vested, it's very unlikely that it's going to vest by your leaving, unless you've negotiated something into your contract or the plan provides that, in certain events, such as a change in control, if you're terminated for other than cause or whatever, some portion of that or all of it will vest. So that's the first question. Unvested stock goes away when you leave. The vested stock then depends on the terms of both the plan and whatever the operating agreement is or the company shareholder agreement, what they say. Usually, if it's a publicly traded company, you can keep your vested stuff. If it's an option, you probably have a limited period of time following your termination of employment to exercise it. And by exercising, I mean pay the exercise price and the taxes, and then get the stock. Or if it's restricted stock, you may just have it after that. And then there may be provisions in the agreement or in the shareholder agreement or whatever that gives the company the right to buy it back from you and again, that may be at its fair market value. It may be at some reduced value. It may be at what you paid for it. In other words, those are all terms that need to be reviewed and potentially negotiated. So there's no absolute yes or no, Nancy, but the answer is in the, written into the terms of the agreements, and that'll tell you what your situation is.
Yeah, and John, I'll just add there that really critical, this is where your advisory team becomes really important, because none of these plans are created equally, and you see different things at different companies. I know for example, I've worked with Sherwin-Williams executives and I've worked with Goodyear executives. Two very different approaches to handling even vested equity when someone leaves pre full retirement age. So really critical that you know how your plan reads. And if you don't fully understand it, bring that advisory team into play, get them involved, make sure they're looking at it, because even within the same company, not all grants look the same.
That's right. And Nancy, it may not have been in your agreement when you started because the company wasn't publicly traded, but it was in some agreement, whether it's in the plan itself, the award agreement, or even in the operating agreement for the entity. It will describe what happens when an employee who has stock or stock options terminates. So it's in some agreement. So moving on, these are the components that we tend to focus on in an agreement. And remember, that agreement might be a contract. It might be an offer letter that you're asking to be signed. It may be company policies that you're required to acknowledge to be bound by. But these are the types of things, and we're going to talk a little bit more about each of these later on. So the first one are the restrictive covenants, non-competes, non-solicitations, confidentiality, things of that nature, non-disparagement. Base salary and bonus arrangements are always a topic of discussion. Equity and equity compensation. Not every company gives out equity. Not every company is comfortable doing that. There may be financial reasons. There may just be people just don't feel comfortable having minority shareholders or whatever. But obviously, equity compensation is something that we always look for. If they don't have equity compensation, then we look for non-equity compensation that might be equity-like, things like phantom stock or deferred compensation, stock appreciation rights, or other things where your payout is derived from the value that the company adds, while you're there, perhaps. Health and welfare benefits, again, typically those are company-wide. We don't see a tremendous amount of companies that are still providing special health or welfare benefits to their executives. Exceptions might be for disability or life insurance, or some type of an executive medical fitness care, but it's pretty unusual. And then perks, and perks used to be a big one that we spent a lot of time talking about. And then when public companies changed the way that they had to report their compensation for executives, so that the value of those perks had to show up as though it were being paid in cash on their proxies and so forth. All of a sudden, the executive said, "You know what? Just give me cash. I'll pay for my own airplane, or I'll ride, or I'll pay for my spouse to come on the airplane, or I'll pay for this or that. Just give me cash, and I'll decide how to use it. Because if it's going to show up looking like cash to the world, I might as well just have it be cash." So why don't we move on? So let's first start with the non-competes and other provisions. As I said, these are the restrictive covenants that we tend to see. Very, very important. And it's not the same for every company. In other words, what might look like, I have a non-compete, I have a non-solicitation, I have a non-disparagement, I have confidentiality. Again, the proof is in the wording of what they do. For the non-compete, and I think this is the one that causes people the most amount of concern, because if you do something and you have a special talent and you're let go, it seems awfully burdensome not to be able to get another job doing what you do. for some period of time. And so you want to make sure that both or all three, the duration, the geographic scope of that limitation, and what activities are prohibited are reasonable, and that they'll allow you the ability to go out and find another job. You know, the old rule of thumb is, and I'm sure it's changed since they made the rule, but for every $10,000 you make, it takes a month to find a replacement job. Now, obviously that's can't be true anymore. I don't think it takes 8 months for an 80,000 person, but the idea being that the more money you make, the harder it is to find the right opportunity for you going forward. And it might require you to move. It might require you, to go through a lot of things before you're ultimately able to get that. If you have a non-compete in place that limits those options, you're just making it harder. So this is something that we'll spend a lot of time looking at and trying to make sure that it's fair and reasonable, and limited to as little as necessary to protect the interests of the company. And do note that every state has different rules about, go back, please. Every state has different rules about, how they enforce non-competes. They're almost non-enforceable in California, for instance, but Ohio here and elsewhere, Michigan and Illinois and so forth, they tend to, if they're fair and reasonable, they tend to enforce them. So don't think you'll just deal with it when you leave. You got to deal with it before you sign. Non-solicitation, I think, is a little bit easier to deal with. And that's just basically saying, hey, you won't take our employees. You won't take people who used to be our employees. You won't take people who are our customers or used to be our customers. And you won't take our suppliers and our advisors. Or you won't do anything that causes somebody that we do business with to stop doing business with us. Again, that's a little bit more reasonable because at least you know what's in front of you. But again, depending on how you negotiate that, solicitation simply means that you reached out to them. And if they reach out to you, that's not always solicitation. So if the wording is one way versus the other, this might not stop a lot of things. If it's you won't solicit, you won't hire, you won't take part in any kind of hiring, and nor will you work for a company hires or something like that, then all of a sudden it becomes a little bit more difficult. Non-disparagement, I hate non-disparagement provisions, even though I tend to put them into the contracts that we write. And the concept there is that you won't say anything negative about the company, the employees or directors or shareholders of the company. I mean, even if it's true, that's technically disparagement. So it's not as though you're saying a fib or you're lying. You can't even say anything that's true. I don't tend to like those. I also try to make them mutual, which says you won't say anything negative about me then. But I tend to try and write those down a little bit so that they're more reasonable. Although I'll be honest about it, in my 35 plus years of being an executive compensation attorney, I have not had a single case come up where someone was sued for disparaging the company with one of these provisions in their contract. I've had people disparage the company. I've just never had one come up in a lawsuit. So, and then confidentiality. I mean, there are laws that stop you from using proprietary or confidential information of your employer. You can't take their customer lists or their proprietary pricing and put it on the internet after you leave or use it in most states and certainly in Ohio. But every company that we work with puts in place a broader confidentiality restriction that makes it very clear, not only that information is confidential, but that anything you do or create or help create while you're there is the property of the company, work product kind of provisions. So. Okay.
Don, we've got another question from Nancy before you move on from this slide.
Excellent.
If you were let go for no cause and signed a non-compete, should you have the conversation before you leave about working for a competitor, or is it too late to negotiate?
So most of that's a great question, Nancy. Most of the non-compete provisions that I've ever seen or written are not dependent on how or why you were terminated. So they apply whether you voluntarily leave whether you are terminated by the company for other than cause and get severance, or terminated for cause and get nothing. So that's the first thing. And again, the provisions are already in place. Now, that doesn't mean, companies are going to have a hard time enforcing some non-competes, particularly if it's really not all that significant of a competition or harm to the company. They would have to be able to demonstrate to a court, some sort of harm or reason why you shouldn't be able to take that position. Why the knowledge that you have from them or about them would put you in a unique or unfair situation to hurt them. So that's always a factor. But if they owe you any money, then they're simply just not going to pay it to you if they think you're violating the non-compete. So then it's you that's suing them, and they're claiming, well, we don't know it because she violated the non-compete provision and we were harmed. And so I guess the answer is, like most of these things, it's best dealt with before, when you do the contract, not after, when you're triggering it. If you are going to trigger it, then, depending on what it is you're going to do and how significant it is, your best course of action might be to go to the company and say, hey, you've put me in a terrible position. I have this opportunity. I'd like to take it. I don't think it's competitive, but here's, and then negotiate what you'll do. Well, I won't call on any of our clients, or I won't do any of this or that, or I'll only work in this particular division on these products and, for the year in which I am bound. So I think that's probably the answer I would give you. I'm going to move on. Thank you. Okay, so
all right, well, John, before we get started on this, I want to get everybody engaged.
Please.
So John and I were chatting a little bit before we talked to all of you today, and we were talking about our first official career jobs. I started at R3 Anderson way back when, and John, I think he mentioned he started at Benish Friedlander, and we were talking a little bit about our starting salaries. I made $28,000 to start. And the question is, did you negotiate your first starting salary? We'd love to hear from you in the chat. Feel free to share with us, yes or no, any details you want to share. I will tell you, I did not. I was just so geeked out to get an offer at a public accounting firm. I was like, yay, I'll take $28,000. That's more money than I've ever seen in my life. I don't know, John, I think you told me you started in like the $19,000 range. And I don't know if you negotiated.
Yeah, that was a job offer I got that I ended up not taking. No, Benish was interesting. I took the job. I think they were paying 33 at the time. Before I ever started, they wrote to me and said, we've raised our base salary to 56. And then after I started, they retroactively raised it to 62. So within one job, I over tripled the salary. But that's a very unusual, and I can promise you there was absolutely no negotiation whatsoever on my part or on anyone's part. The only negotiation was to what address to send it to.
Well, and I will tell you, John, and looking at the chat, it sounds like most other people were in the same boat as us. There was really no negotiating when they took on their first jobs, or if they did, it wasn't a good outcome. John shared with me yesterday that laws are changing in a lot of states. So in many states, the employers can't require you to share your current salary. So it may not necessarily hold you back forever. But what's interesting is, just if I would have negotiated $5,000 more of salary at age 29, if you do the math over if you work till retirement age 65, that would result in a 300,000 plus increase in my wealth. So I should have done it, but I didn't. It sounds like a lot of us didn't, but that's why we're here today. I love what Heather shared. She said, well, no, I didn't for myself, but by the time my kids came around, I was smart enough to make sure I helped them to do it. So it's great to learn these lessons. It's great to share them with the family and the children so that they don't make the same mistakes we did.
Great point. I'll tell you, with respect to base salary and bonus amounts, most people are best able to negotiate for themselves on these things. Even when I'm representing an employee, for the most part, if they're an executive, you know, you have to be pretty subtle about how you handle these things. It's got to be professional, because when you're all said and done, you're going to go work with these people. And so you can win the battle but lose the war if you turn people off, or if you're a jerk about how you handle these things. So for the most part, when it comes to the big things, I'm behind the scenes explaining to them, okay, this is, working with them to come up with a strategy of, ask for this, ask for that. These provisions need to be changed. Then once they have all the terms, I might end up having, direct negotiations with an attorney on wording and things like that. But people generally are their best negotiators. Everyone's always a little bit afraid to do that, because you're afraid that you're going to lose the job if you push or this or that. But I always tell them, look, they're hiring an executive, they're hiring a business person. What kind of business person wouldn't take care of themselves and ask these types of questions? It's part of the process. And as long as you're polite about it and reasonable and friendly about it, I've only had one case where they took the offer away, and it turned out it had nothing to do with that. It turned out that they found out some dirt about the person, which was why he was available for that position based on what had happened at his prior employment. So, I'll reiterate the same thing I said earlier. Pigs get fed, hogs get slaughtered. Be reasonable, figure out what's really a priority, figure out what your leverage is, and then seek, what you can, and be willing to compromise, and or sometimes it's okay. They like, I had a person the other day, and the offer was a pretty good offer, and they went back and asked for a lot more, and they asked for a lot more equity. And they came back and said, well, we can give you one or the other. We can give you a lot more, which will also mean more of a bonus, and no equity, or we can give you the equity and keep it at this. And so what we changed it to was, fine, we'll take the salary and the bonus and not the equity, but you agree to sit down with us in 6 months and negotiate equity. And they agreed to that. And it was, perfect solution. You didn't miss the boat, got the sure thing, which will, as Emily said, play out throughout her career, because she basically raised the bar by 35% immediately, and everything tends to move off of that, and still has the opportunity for the equity. So, and the only other point I will make here is that a bonus is not a bonus. So simply having the right to a $50,000 bonus, or 35% of your pay, or whatever it is not the only issue. It's how is it calculated, when, by whom, how reasonable are the expectations, how are they set, who makes the decision, when is it, when do I have to be there to get it? Sometimes you have to be there through the end of the year, and then they pay it after. Sometimes you have to be there on the day it's paid. So you work for the year, you earn a bonus, they're calculating it, normally pay it out at the end of March. You get terminated at the beginning of March, you wouldn't get the bonus in that case, unless your contract somehow or another did that. So the proof, again, is in the actual wording of the provisions. And so, apples and oranges sometimes. So keep that in mind.
I want to pipe in here just with a couple comments and share some things from the chat. Number one, just note that signing bonuses are a great way to recoup benefits that you might be walking away from at your previous company. So for example, if you are within a couple of months of a vesting grant, but your new employer really, really wants you to start now, share with them you're walking away from a grant that's about ready to be vested, and a way that they can pretty easily bring you back to even and bring you back to whole is to put that into a signing bonus.
Yeah, that's a great point. Or it could be a special grant of equity or deferred comp, or some other factor that replicates what you're walking away from.
Right. I want to share okay, so remember I told you about Dave, lesson learned in a negative way. We actually leveraged that lesson with Carol. And Carol was looking at a new job, had a fantastic job at a company, but got a great opportunity. She was walking away from some vesting grants, and the new company offered her a 3-year cliff vest restricted unit. I flagged Carol to the experience I had with Dave, and Carol's like, oh gosh, is there anything I can even do about it? And I said, well, just go back to him, kind of, share with him. I'm concerned. What if you decide you don't love me anymore and terminate me not for cause? Fast forward, Carol actually got them to make an adjustment to the way they were providing her with that compensation. And it was noted that if she was terminated for any reason other than cause, that her grant would still vest. And lo and behold, she did terminate from the company prior to that grant vesting, and it vests next year now. She's still getting it. So I think Carol is forever grateful that, we flagged her to that. I don't think she would have thought of it. Again, she didn't go into that job thinking it wasn't going to work out. And she now is receiving still that compensation. So again, just keep in mind, it never hurts to ask. I keep hearing the pigs get slaughtered comment in my head. But again, I think if you're professional about the way you approach it, companies can and will from time to time be flexible. Although I will say, Beth and Brescia shared with us that she had an employer tell her, you don't need more salary because your husband works. Now that is shocking. That's ridiculous. So I wanted to share that with everyone. And then we do have another question from Nancy, John. Do you have to give salary information on the application, or can you leave it blank? And Nancy, great question. I asked that yesterday, and I know John has a great answer.
Okay, I'm dying to know what it is. So the answer is that you're not required to give anything. You don't have to give it. In some states, they can't even ask for it. They can ask what your expectation is, because that's your expectation. So you can say, I'm looking for, between 230 and 270. I'm looking between 100 and 110, but they can't, in those states, ask, what you're earning. And whether you give it or not, I'll leave it to you in the states where they can ask for it. If you don't provide it, they may look upon that negatively and not consider you seriously. So I think there's a judgment call. But you're not required to give any information. It's just if they ask for it, you don't give it, they're likely to look at you a little bit differently. And I don't know the list of states. I see that just popped up off the top. I know New York City is certainly one of them, but more and more states are looking at that, and not only states, but some local jurisdictions and cities are doing it for obvious reasons. It perpetuates discrimination. In other words, if you look at what the average woman or person of color works versus a male, Caucasian male doing the same job, the rates are pretty staggeringly upsetting. And part of that is because if they started lower and they take a new job, well, they figure I'm not going to pay them the same rate I would pay someone I had to hire if they were only making. I'm not going to pay them 150,000 if they were only making 70. I could probably offer them 90 and they would take it. And so it just perpetuates. So if you can't ask that question and don't have to provide it, that when you move jobs, that at least gives you the opportunity to right the ship. Okay, let's move on.
John, I have one more question for you from Jennifer. Jennifer's asked, how do you recommend finding out what others at your firm get paid so there is more transparency around base salary? I know this topic is very taboo and highly sensitive, but how else do you know if you're being paid your worth, and tying up, of course, this into the gender pay equity?
Well, there are a lot of surveys and things like Glass Table, I think it is, or
Glassdoor,
Glass Ceiling, or whatever it is. Sorry, and things like that, where that kind of information is tracked more anecdotally than maybe precisely, but nonetheless should give you an idea. I'd be very careful about sharing it with your coworkers in any way that could be deemed to be a violation of the confidentiality provisions of your agreement. A lot of agreements don't allow you to have that kind of conversation. I'm not sure what would happen if you did, but you don't want to obviously violate a provision that you've agreed not to do. So I guess
But
that's
yeah,
the best.
specifically, Jennifer, John mentioned it's glass door, fortunately
Glass door.
not glass ceiling.
I'm
And
a little
also, there's some surveys like Korn Ferry, for example. They are a recruiting firm and an executive coaching firm. I think they do some salary surveys as well. So these days, when we can all jump on our Google machine, there's a lot of information to be had just on salary ranges for similar positions.
Excellent point. And I should mention that obviously you can do a lot if you have a friend that is a recruiter and has access to any of the proprietary surveys, or if you just go on the internet, you're going to find a lot of information as well. It may not be completely accurate or up to date, but it should be very helpful.
And Trish Cox, thank you for sharing. In her experience, asking your boss to engage HR to benchmark is a good way to go.
Yeah. I think periodically every company should be doing that from time to time anyway, both to make sure there aren't any internal inequities among their staff, but also to make sure that they're properly paying their people so that they don't lose them to other companies that are paying more for the same kinds of jobs. So, HR benchmarking and then actually adjusting things to stay within wherever the norm is that they want to be is just a standard part of HR practice. And thanks for bringing that up. Okay, equity compensation, I want to be mindful of our time, but we love the questions and we'll keep answering them. And for those that have to get off at any particular time, if we're still talking, we apologize, but we'll talk until you guys are done listening. Equity compensation is probably where I spend a good portion or the most of my time. And because it's really, when you think about it, it's the one opportunity. I mean, people get rich from that. Microsoft in the 90s or whatever, made a lot of millionaires. And it was not because they were paying a lot of salary. It's because they were granting equity. In that case, it was stock options to across the board. And even the lowest paid people, were gaining wealth, and they were also using it in their retirement plans. And so, equity is the quickest way to make a lot of money potentially, and it puts the employee in the same position as the shareholders as far as thinking long term, what's the best interest of the company and of the shareholders of the company. By making them shareholders, that they're going to think that way. So rather than worrying about this quarter or this week, that every decision has a long term thought to it. Does this, in the long term, am I making the right decision? So better companies tend to do well if they've offered equity. Not, as I mentioned before, not every company offers equity, but then you can get to the same place by using phantom equity. I can give you a deferred compensation agreement that says that I'm going to give you the equivalent of the gain of 10,000 shares of stock if you owned it under these conditions. So you can get to the same thing. Do recognize that 10,000 options is not the same thing as 10,000 shares of restricted stock. Mm-hmm. It's not the same thing as 10,000 phantom units. It's not the same thing as even profits interest, which is a very unique way that partnerships can give equity. There are tax rules that impact the value of that. There are all sorts of interior rules of how they work when they vest, what happens to them when you leave, and for what reasons, that absolutely impact the value of those and need to be considered. So simply, them telling you we're going to give you 10,000 stock options doesn't really tell you a lot unless you understand, okay, what's the exercise price? What's the value today? When do they vest? Under what circumstances? And what happens, when I exercise them? Do I get to keep the stock? When does it get paid back? When does it get bought out? Things like that. So because of that, there's a multitude of ways to go, and a whole continuum from value, from the lowest value to the highest value, depending on how well you've negotiated and how fair the plan is. So keep that in mind. Very flexible, but it's where we spend a lot of time and a lot of thought.
And just a couple quick comments on the options to tie it back to some questions we had before. Incentive stock options, for example, they may be vested, but once you walk away from a company for any reason, whether it be full retirement, whether it be, you're leaving just because you want to go somewhere else, those incentive stock options only keep their ISO status for 90 days after you leave a company. And then all of a sudden they become non-qualified stock options. And, ISOs, not a lot of companies give them out these days. I still happen to work with one that does. They're beautiful because for regular tax purposes, they are not taxed. They're only included for AMT tax purposes. So it's wonderful if you are granted those options. You want to make sure you maintain that ISO status. And there's lots of rules that you have to follow, not the least of which is, you have to exercise them within 90 days of leaving. You have to make sure that you actually hold the options for an entire year before selling them. So again, that's where, we talked earlier about the advisory team. That's where they come into play, because we really understand the ins and outs and the inner workings, and we read these plans, all of which may be drafted different by different companies in different years, even in the same company. So just keep that in mind.
Yeah, and just to add to that point, you really need to understand that before you leave your present job too, because as I pointed out before, if there are provisions in there that would require you to have exercise before you give your notice or before you leave, it wouldn't be before you give your notice, but and you give your notice and they just say, fine, you're out today.
Yep.
All of a sudden you didn't exercise that option. So you need to think through that. There are other vesting or other provisions that you need to be aware of, because there could be a huge difference between giving your notice next Friday versus waiting 2 weeks later to give it. And you need to understand and accommodate for that.
Yeah, John, a cautionary tale on that. I worked with an individual, Tom, who his division was being rolled out of his company. And he headed the division, found out right before they were getting ready to roll out the division that if he didn't immediately exercise even his vested stock options, that he was going to lose them because he wasn't full retirement age and was terminating from the company. So again, really critical that before you're giving any notice or leaving certainly leaving a company, that you know how that works and what you need to do.
Yeah, and I would also just point out, periodically, even if you're not planning on leaving, you should be sitting down with, Emily or someone like Emily or me, and looking at what you have and trying to decide, what I have these out here. Do I need to be doing something? Would it make sense for me to, for instance, exercise these stock options early? We negotiate a lot of times now what's called an early exercise opportunity, where people can exercise their stock options before they even vest. And the purpose of that is to so that they have, because when you exercise a stock option, unless it's an incentive stock option, and I'll be honest, I haven't seen an incentive stock option in years. And when you exercise a stock option, what happens is you pay for the exercise price. Let's say it's $10. If the stock is trading at $25 at the time you exercise it, you have $15 of compensation, similar to if pay, and they'll tax you on that. So you're going to have to pay $10, and you're going to have to come up with $6 for the withholding, and then you'll have a share of stock that's worth $25. Now, some have cashless exercise, so you can use shares to do that. Some don't. If you can exercise that option and feeling confident that either you're going to be there till it vests and it's going to rise, or having a provision in there that protects you, and I'll explain what that is, then you may consider early exercising it when it's still at the $10. You pay the exercise price, but there's no compensation. Thereafter, when you eventually sell it, assuming you've held it for more than a year, you have long-term capital gains, which are obviously taxed at a much lower rate. presently than than ordinary income. So there are some tax strategies in how and when you exercise that kind of thing. And that's why I spend so much time on equity compensation, because we're always looking at not only the value of it, but then what's the tax situation? When do you get hit with tax? At what rate? We're looking at what is the risk to you, and how do you protect yourself of holding that if the stock goes down or whatever. So there's all sorts of things that you're negotiating. And one last point I'll make is that I'm sure all of you have heard that the present administration is looking at changing the tax rules for significant taxpayers with significant income. And those new tax rates will take the capital gains, if they're passed as proposed, would take the capital gains rate up to 39.6 in some circumstances. So for my most successful executives, all of a sudden, they gain nothing. They gain no value from having this capital gains, long-term capital gains opportunity than they would if it were just ordinary income. So we don't know what these rules are going to be, but I can promise you that they're going to change how we provide and ask for equity compensation going into the future. If you're in that kind of a situation where you expect that you're going to be paying this super capital gains tax, you'd be better off just taking it as compensation, because you could likely get more and the company would get a deduction, and they might be willing to give you more. So the rules are going to change a little bit as that occurs. Why don't we move on to the next one, unless there is a question that we need to answer. Okay, well, let's go.
I've got a couple questions for you, John, but I'm going to pause and I'm going to ask a few of them after we get through these next couple slides.
Okay, perfect. So retirement plans are always a big thing. We don't tend to see qualified retirement plans changed for, you can't negotiate the company's retirement plan. Usually it is what it is, but you should understand what it is. In evaluating your opportunity, if they have a 401k plan and they don't make an employer contribution or a match, that's not nearly as valuable as if they have a defined benefit plan or they have a very significant employer contribution or a matching contribution. So you need to factor those in evaluating whether this really is a good job. And then look at vesting and the other provisions as well.
And John, I'll say this is a place where I've seen people get frustrated because maybe haven't done enough homework and didn't think about the fact that, oh gosh, that employer that I left, I got a profit sharing contribution. They had a great company match. And all of a sudden I walk into this new company and boy, they don't even do a company match. So again, this is an area to focus in on, and this affects everybody. Everybody's got access to a retirement plan when they're working at a company full time. So ask the right questions. Do they have a match? Do they do any profit sharing? Do they offer a Roth 401k or 403b option? That would be great too. Not all companies do. Many do these days, but again, you want to know. You want to ask the right questions.
Right. And as we said, it's not likely that you're going to change what they do, but you need to understand it in evaluating whether or not you really this is a better job for you.
Right.
Now, the non-qualified deferred comp plan, and that takes the form of a lot of things. It might be what we call a SERP, or supplemental executive retirement plan. It might be a deferred comp where you're allowed to defer some of your salary over time, and then it's paid out to you at a later time, so you're not paying taxes on it. It's building a little bit more quickly. It might be a bonus plan that they give you of additional amounts that they defer, and it could be anything in between those. So. And those, for the more significant positions, that tends to be part of the negotiation and part of the offer of what they're going to do for you. Up till you get to more of an executive level, that's unlikely that you're going to participate in these kind of things. Most of them are designed to be top hat plans, which mean that they really are only designed for the key employees and the highly compensated. But nonetheless, these can be very interesting and can be very lucrative. And again, the specific terms need to be understood and potentially negotiated. And this is where, if you've been working for 20 years and you're pretty significant, you go take a new job and they're telling you, well, guess what? you're a new employee, sorry. So you don't vest for 2 years in this. You can't start participating in the retirement plan for a year, on and on and on. Then here's where they could potentially make up some of that with a non-qualified deferred comp that credits you with the value of those years. In other words, if there's a pension plan that's based on years, maybe they give you a credit for some of your prior years in coming up with that in this non-qualified plan. There aren't any discrimination rules that would typically apply to a qualified retirement plan where they can't give it to you in a qualified retirement plan. Here they can do that. They can discriminate all they want within certain confines.
And just one quick comment on non-qualified deferred comp and specifically SERPs. If you have a SERP, it's not rollover eligible. So when you leave the company, oftentimes they will offer you just a lump sum option. Some companies offer annuitization of their SERPs, but when you're taking that payment, you're taking it all at one time and you're taking it and getting taxed on that payment. So we see that a lot, that year after retirement, lots of big taxable income years. And that's the fun times when you can do things like set up donor advised funds and find other ways to save taxes. So
yeah, and that's a great point, Emily. Let me just stress that if you're leaving a company after you've been working it for a long time and taking your supplemental retirement plan, or you're taking your deferred comp, for the most part, most states now are pretty aggressive about treating that as compensation in the state in which you earned it.
Yep.
So if you were in Ohio or Illinois, and you worked for 25 years, retired and moved to Florida and got paid out your retirement over a year or two or three, they would come back and say that's subject to Illinois taxes, even though Florida doesn't have a state tax. There are some ways around that. If for instance certain types of plans are exempt from that, or if you take it out in what's in an annuity or some payment form that's at least 10 years, a lot of times you can avoid that. So it's another thing to think about. Okay.
So now we talked a lot about pay. I think we're going to move on to some perks, right, John?
Well, we're going to do health and well-being first, real quickly. I don't think of these as perks.
Yeah, they're kind of a necessary, right?
Yeah, these are all just provisions of the new employment that you need to be aware of and potentially even negotiate. You're not going to negotiate a new medical plan, but you ought to at least understand how it works. You might be able to negotiate being in part of an executive physical or some sort of super plan. But the discrimination rules are pretty tough for most companies, and they tend not to do these that often anymore. They may have an executive physical because that's a really controlled thing, but they don't tend to have a different plan for their executives than they do for their non-executives. So there's not a lot. Life insurance is a different one. You can potentially have a death benefit that is individually negotiated, or however, so that may be something to talk about. Disability, you could have an individual policy. It doesn't necessarily have to be across the board. So that might be something to talk about. And of course, vacation, usually most companies have a set, you're here for 0 to your first year, you get 2 weeks, the second, 3 to 5, you get 3 weeks, 5 to 12, you get, and you can potentially negotiate a better deal for yourself. Treat me as though I've been here for 10 years since I'm leaving my job where I was there for 10 years. You might be able to negotiate that again. So those are things worth considering. Sick days, I've never seen anyone negotiate that. That's generally company-wide.
And the one other thing I'll flag here is just another spot to ask questions. If the company has a high deductible plan and offers an HSA, they may even offer an HSA match. And let's remember what they call HSAs, triple tax protected, tax-free on the way in, tax-free growth, tax-free on the way out, as long as you use it for medically related expenses. So if you happen to work for a company that offers an HSA and gosh, maybe even matches it a little bit, wow, that's a real nice benefit. Again, you probably can't negotiate it, but ask the question, because if you're walking away from it, you'll be awfully ticked off when you no longer have it. If your new company doesn't offer it, maybe you can negotiate a higher salary because of it. So
and that's a great point. When you talk to people about the best way to save, I suppose the best way to save is to the 401k with a matching contribution, because that's just free money. But right after that is the HSA, because as Emily mentioned, it's not taxable to you when it goes in. It can earn money, and then you can pull it out any time that you've incurred an expense. So I can pull it out 20 years from now because this year I paid an expense out of pocket that could have been paid out of that HSA. So, or I can use it to pay my social Medicare. I can use it to pay my nursing home. There's a lot of things. So most of my clients that have HSAs just build up the balance.
Yep. I will tell you, it took me too long to figure that out for myself, John, but I don't use my HSA at all now. I max it out every year and I invest it and I'm letting it grow, hopefully become a really big asset, tax-free, that I can use down the road for all these expenses John just mentioned.
And it's totally portable, which means that, unlike some of these other things where it's yours, you leave in your name. It may have been done through the company, but it's yours. So
all right, let's fly through some of these perks, John. We're running out of time.
Yes, we are. I'm sorry.
So we can move on to the next slide, Annika, and let's chat perks.
So real quickly, perks are perks. You all know them. As I said, in most publicly traded companies, we don't see a lot of this anymore. But club memberships, organizations that you want to belong to, things like that, cell phones, car reimbursements, auto and reimbursements, education, they're all part of the package. Understand them, take advantage of them, and to the extent that you're going in and you think it's important to you to have them pay for this or that, or to reimburse you for this or that, then ask for it.
And I will tell you, this can be an area that can be extremely meaningful. I actually was talking with a woman, Shelly, who for her job, she had to be a member of an organization that cost her something in the neighborhood of $40,000 a year. Shelly was able to negotiate to get her company to pay for that. But gosh, could you imagine if you had to pay those dues on your own? This is a kind of an under-considered, but a really good area where companies can be flexible. You can talk about this a lot on the way into a job, and you can negotiate something that is beneficial for you. So don't miss out on that opportunity. I mean, home office setup, boy, all the more important these days that a company will support you in your home office, considering many of us are working from home either full-time or at least will be continuing to do so in a hybrid fashion going forward. So don't undercount these with the impact that they'll have on your compensation package.
Yeah. Annika? Just a few others. We talked a little bit about them. Flexible hours. I know, Emily, you probably care a lot about, or you have clients that really care about that. Those are things we didn't used to even talk about, but now, some people consider it a huge value to be able to either work from home or to be able to come in after their child is on the bus, or get home, before this or whatever, or they have someone that they have to pick up from daycare every day. Those are all valuable things, and they have to be taken into consideration when you're looking at this new opportunity. Does that make it more valuable to me?
Next slide, please. Lifestyle considerations. I think two biggies that I just want to focus on for a moment is company culture. And then we can talk in a second about relocation. But company culture, key. I mean, to John's earlier point, people don't leave for money. They leave because, they don't like their boss, or because, gosh, their coworkers aren't very nice. Well, thank gosh, that's not my problem. But ultimately, what's the way to figure out if a company has a good culture? I think a great way is to make sure that during the interview process, you are talking with people at all ranges. So not just the people that'll be your boss, the people that will be your peers, the people that may report to you. Try to get out in a more social setting, like maybe a lunch, see how they interact. Ask all the right questions. I know that this is an area that is rife for issues. You could make really good money and have a really great job, but if you work in a company that has a bad culture, you're not going to stick around for very long. So, that's one item I wanted to focus on. Just another I wanted to share with you is, relocation. Now, these days it may look a little different. We don't really know how it's all going to pan out. But in many cases, previously, people would have offers to leave their company and move to another state. And don't again discount this as somewhere that you can't negotiate. We've seen, as a matter of fact, I believe Heather, actually, it's one of the clients that Heather has worked with. She was able to negotiate for a company not only to pay for all of her moving expenses, but to take her house and to help her to sell it because they really wanted her that badly. So they hired a company to take her house and make sure it got sold. And, now that wouldn't be such an issue. It's a hot market, but back at the time, it was a major issue. So again, an area for negotiation, moving expenses are no longer deductible. So if you can get that company to cover it, do it, do it, do it.
Agreed. Annika?
Next slide, Annika. All right, negotiate an offer that works for you.
Okay, so real quickly, if you can move on, Annika. The most,
I love this quote. Actually, I learned this quote. We teach other people how to treat us in one of these presentations. We did a presentation for the YWCA and a woman shared this, and I think it's really meaningful. So next slide, please, Annika.
So real briefly, this is such an important area that we decided we would cover it alone, which is severance and retirement. What things look like when you leave, and for the most part, if you leave voluntarily and it's not for what we call good reason, that you've been demoted, your pay was cut, your responsibilities were significantly changed, or you're being asked to relocate or some other reason like that, then you can't really expect severance. And it's very rare that you would ever see anything like that. But if a transaction occurs and all of a sudden, or you're being asked to leave and it's not for one of those reasons, or you retire, then you may have the right and to expect that they're going to take care of you. And these are all the areas that we focus on. And because of the lack of time, I'm not going to get into each of them in any depth. But the golden parachute is basically, on a change in control, what gets triggered. And it's very important, for instance, if you have options or if you have restricted stock or some other deferred compensation, that it doesn't go away if they sell the company before they vest, that there should be an opportunity to accelerate the vesting. And that might just be a pure acceleration, or it might be let's look at, if there's performance metrics in them, you had to reach revenue of this or that. Well, then let's look at that at that time and judge whether or not to accelerate some or all of them. Cobra eligibility is the same one. If you're terminated, in addition to getting severance, which you may need, because as we talked about, it may take a while to get a new job, you may have to go under Cobra. And I don't know if any of you have done Cobra lately, but the cost of Cobra for a family can be $2,000 a month. And that's the portion. That's technically what it's costing the employer for you minus whatever you contribute for yourself. So it's very expensive. So if you can get them to agree to not only pay you for 6 months, but to provide Cobra to you at their cost, for them to pay for the cost of it, that's valuable, especially at a time when you need healthcare and don't have a lot of funds to pay for it. Executive coach, a lot of people ask for that type of thing. Accrued PTO, not a huge issue, but in our severance discussions about what severance will be, we will also often ask for, not only X number of months or years of your base pay, but maybe your bonus, or maybe accelerate that year's bonus on a prorated basis. There's all sorts of things you can ask for. And depending on how much leverage you have, you can expect to get. And then lastly, and this is the huge one, is the equity compensation forfeiture. I like to think of it more as acceleration, where under what circumstances did these grants that they gave you that you were counting on and that you've helped build up this value for, do they become vested and of value to you because they terminated you? And it's something I rarely see offered. You almost always have to ask for that, but it can be incredibly valuable to you, particularly if there's a transaction. Emily?
All right. Well, I think we talked earlier, a lot of us don't negotiate for ourselves. It's kind of easier to negotiate for someone else than it is to negotiate for yourself, I find anyway. But, just wanted to provide you with just a few thoughts on this. Ask for more time to consider the offer. There's never I wouldn't think that there's ever any negativity with an employer if you say, I really want to be thoughtful about this. I want to take a look at it. I'd like to confer with my advisor. I think knowledge is power. Taking the time to process what's being offered you, to compare it to what you currently have, is really critical. So that's really just what I wanted to share here. Next slide, please, Annika. And we can move to the next slide. So the career transition checklist, I think this is the tell them what you told them part. Build an advisory team. Obviously there's a lot of nuances to this. You need somebody on your side. A lot of times when you're making these kinds of decisions, it's highly emotional. And when you get emotional, you're not always able to process information rationally. So bring somebody else to the table to help you think through these things. Compare what you have versus what you'll get. What we'll often do is just a simple Excel spreadsheet. List all the benefits from monetary all the way down to non-monetary. Put the two companies side by side, fill in the blanks. It's a really great visual way to see, what do I have? What am I going to get? Review the whole package, including the non-monetary features. If we impress nothing else on you today, it's those perks where you have some negotiating power and opportunity, and negotiate an offer that works for you. Next slide, please.
Oh.
All right, so I had gotten a few questions in the chat about sharing our information. My email address is included here. I think on the next slide, we have John's email address. And I just want to share with you folks before we close, attended a wonderful negotiating webinar, actually that our parent company, Hightower, had put on. And I learned some really cool things. It's actually Kathleen Kingsbury did the webinar. And if you wanted to see the webinar, I think I can even send it to you. I found it on YouTube. But she also has, I think, a website called Breaking the Money Silence. She shared some reasons why we don't negotiate for ourselves: fear of conflict. Our money messages that we grew up with might deter us from wanting to negotiate. And as we talked about, money talk is taboo. Nobody wants to talk about it. As a matter of fact, 44% of Americans say they'd rather talk about death, dying, or politics, or death, taxes, or politics. I'm like, okay then. But in any case, how do we get better at negotiating for ourselves? I think we need to know our values is really key. If you know not only your value, which is what we talked about for most of this presentation, but also your values, that will help to drive you on what you should negotiate, what is important to you. So how do you figure out what are your values if you haven't already? I actually, through a book club I was in, found a very cool values test, and I've got a web link to it. I will share it with anybody who's interested, but it's https://personalvalue.es/personal/values/test. We will share that with you after the program. I thought it was a super fun exercise to understand my values and to kind of tie them back to the company. And I think it really does, as I think through my career trajectory, it has driven what I've negotiated for, because those are the things that are most important to me. So I think you will automatically become better at negotiating for yourself if you're doing it from a place of authenticity and based in your core values.
I agree. And my only closing comment would be understand, the rules. So you have to understand your present agreements, take a look at the new opportunity and really understand it, figure out what your priorities are as far as things you'd like to change or add, and then come up with a strategy for getting those. And I don't think employers, for the most part, appreciate a business person that acts professionally. And so if it's done well, you're likely to get some benefit from it. And it could be very, very beneficial if you do it really well.
Excellent. Well, thank you everyone so much for your time and attention and engagement today. We so appreciate you being here. It was fun doing this again. It's been a couple of years, but as I'm sure you saw, John's a great partner in this, and
Thank you.
we're happy to answer any questions that you have. Please don't hesitate to reach out to John or me, and of course, anybody on your advisory team.
Thank you, everyone.
Thanks all.
Bye-bye now.
Bye.